Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a Lawcast series talking about Regulation A, and in particular, today I'm going to talk about eligibility requirements. Regulation A and A+ is available to companies organized and operating in the United States and Canada. A company will be considered to have its principal place of business in the U.S. or Canada for purposes of determining Regulation A eligibility if its officers, partners, or managers primarily direct, control, and coordinate the company's activities from the U.S. or Canada, even if the actual operations are located outside of these countries. The following companies are not eligible for a Regulation A offering. Companies currently subject to the reporting requirements of the Exchange Act. A company that was once subject to the Exchange Act reporting obligations but suspended its reporting obligations by filing a Form 15 is eligible to use Regulation A. A company that voluntarily files reports under the Exchange Act is not subject to the Exchange Act reporting requirements and therefore is eligible to use Regulation A. A wholly owned subsidiary of an Exchange Act reporting company parent is eligible to use Regulation A as long as the parent reporting company is not a guarantor or co-issuer of the securities being offered. Investment companies registered or required to be registered under the Investment Company Act of 1940, including BDCs, are not eligible. Blank check companies, which are companies that have no specific business plan or purpose, or whose business plan and purpose is to engage in a merger or acquisition with an unidentified target, are not eligible. However, a shell company is not prohibited unless that shell company is also a blank check company. A shell company is a company that has no or nominal operations and either has no or nominal assets, assets consisting of cash and cash equivalents, or assets consisting of any amount of cash and cash equivalents and nominal other assets. Accordingly, a startup business or minimally operating business may utilize Regulation A. Companies seeking to offer and sell asset-backed securities or fractional undivided interests in oil, gas, or other mineral rights are not eligible. Companies that have been subject to any order of the SEC under Exchange Act Section 12J denying, suspending, or revoking registration, which order was entered within the past 5 years, are not eligible. Companies that did not meet their ongoing Tier 2 Regulation A+ reporting requirements over the past 2 years are not eligible to do another Regulation A. Companies that are disqualified under the bad actor rules, and in particular Rule 262 of Regulation A, are not eligible. Unfortunately, in what is clearly a legislative miss, companies that are already publicly reporting, that is, are already subject to the Exchange Act reporting requirements, are not eligible. OTC Markets has petitioned the SEC to eliminate this eligibility criteria, and pretty well everyone in the industry supports a change here, but for now, it remains. Regulation A can be used for business combination transactions, but it is not available for shelf SPACs, SPACs being a special purpose acquisition company. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.